Very good evening, students. Very good evening, Sapna. Very good evening, Amit. Okay. Very good evening, Amita and Aditya. So let's start this session now. First of all, I welcome each one of you to my YouTube session on the Indian Evidence Act 1872. So let's start with my brief introduction. First, my name is Sandeep Khatri. I have done my law from University of Mumbai and my LLM from Jindal Global Law School. By profession, I am a teacher. My areas of specializations are the constitutional law, criminal law, commercial law, family law, and law of torts. This is the link of my profile on Unacademy. Please follow that to get all the updates about my special classes and my plus courses. This is my Telegram channel where you can connect with me to ask any kind of queries related to judicial preparation. And at last, I have mentioned my code, that is Khatri Live, basically my surname KHATRI Khatri Live LIVE, which you can use to get free access of all the special classes available on Unacademy app, and also to get 10% discount for all the plus courses. So this was about me. Uh, Now I request everyone, please be attentive, and this is going to be an interactive session. So today is the last session on the Indian Evidence Act. Yes, we are done with Indian Evidence Act, almost all the MCQs. And students, from tomorrow onwards, I'm going to start with Indian Penal Code 1860. Okay. So I hope everyone is doing fine. Okay, students. So I'm starting this session now. And here comes your first question. Before starting the test, students, again, humble request, please write down first the question number, numeric. For example, question number 1, so numeric 1, and whatever your answer is, A, B, C, D, whatever you feel like. And here is the question. A court has no discretion regarding proof of a fact in the context of. First one to answer, Amit, then Aditya and Sapna. Top 3 to answer, C. Yes, Amita, C is the correct answer, which means conclusive proof is something which is irrebuttable. Fine. See, the questions are same. It is just the way they are asking it. Okay. So basically, may presume and shall presumes are the rebuttable presumptions, and conclusive proof is your irrebuttable presumption. And this question is from section number 4. Now moving to the next one. Test identification parade can be held by. Who can held the test identification parade? Wonderful, Amit, if you know the section number as well. Okay, first one to answer. Correctly, Sapna, followed by Amit. So 2D is the correct answer, which means any of the above. So any of the above includes any person, magistrate, and police as well. So that is why the correct answer is D. Next. Dudnath Pandey versus State of UP deals with one of the landmark judgment, students. Dudnath Pandey versus State of UP. This case is related to which one of the following concepts? First one to answer correctly, Sapna, followed by Ravi, and Amit Pandey. B is the correct answer, students. B is the correct answer. That is section number 11, plea of alibi. Also known as residuary provision. Section 13 applies to what kind of rights? First one to answer correctly, Sapna, Amit, and Amita. Top 3 to answer correctly. Students, C is the correct answer. Aditya, Saurav. When it comes to section number 13, it deals with both public and private rights. Section 23 deals with criminal, civil, both, none of the above. First one to answer this, Sapna, followed by Aditya and Amit. B, civil is the correct answer. Irrelevant confession become irrelevant when made in this question, students, I have given you 5 options, so please choose the most appropriate one. Okay, first one to answer correctly, Kirti Gupta. Yes. Followed by Amit Pandey. Yes, students, the correct answer of this question is to police officer. Irrelevant confession becomes irrelevant when made because of section number 25 to the police officer. When it comes to the concepts of under promise of secrecy, or if the accused is drunk, or deception practiced on the accused, all these 3 points, A, C and D, all these are part of your section number 29. Okay, so that will stay relevant only. Fine. Next, judicial confession means. What is the meaning of this term, judicial confession? Yes, Amita, timings are going to remain the same from 7 till almost 8. Okay. From tomorrow onwards, I'm starting with IPC. And all these classes will help you in your Rajasthan Judicial Services or any other judicial services examination that has Indian Evidence Act in their syllabus, and even for your APO exams as well. First one to answer correctly of question number 7, Aditya. This time, first one to answer correctly, then followed by Achal and Sapna. D is the correct answer, students. Confession before magistrate. This is basically your section number 164 of the Code of Criminal Procedure 1973. The constitutional validity of which of the following section has been upheld by the Supreme Court in state of UP versus Dioman Upadhyay 1960? Yes. First one to answer correctly, Sapna, followed by Amit and Aditya. Students, section number 27 is the correct answer. Next. Theory of confirmation by subsequent facts. Which section is this one, students? First one to answer correctly, Gaurav, I'm not sure that you have answered for ninth one only. So, Sapna, Amit, and Kirti. Top three to answer. Section number 27 is basically, you can say, the theory of confirmation. Kashmira Singh versus state of MP relates to. First one to answer, Sapna, followed by Aditya and Prasiddhi. D is the correct answer, students. Kashmira Singh case is a landmark judgment on confession of co-accused. Pakala Narayan Swami versus King Emperor relates to which of the following concept? First one to answer, Amit, followed by Sapna and Prasiddhi. Yes, C is the correct answer, students. Dying declaration. Now here comes the maxim. This maxim is applicable on section number, one of the most famous maxim. First one to answer, Amit. Amit and Ultra is the top two students who has answered the first one. Students, the answer is section 32 clause 1. Okay. Necessity rule regarding the admissibility of evidence contained in section number. Which of the following section deals with the concept of necessity rule? First one to answer correctly, Aditya, followed by Sapna and Prasiddhi. C is the correct answer. A dying declaration can be oral, writing, etiquette, method of communication, or all of the above. First one to answer, Sapna, followed by Amit and Aditya. D is the correct answer, students. Dying declaration can be oral, written form, or any other method of communication. Sections 40 to 44 deals with the relevancy of. Which of the following is the appropriate answer here? Section 40 till 44 deals with the relevancy of. Sapna, first one to answer, followed by Prasiddhi and Amit. B is the correct answer, students. Top three to answer, B. The report of a medical officer stating the injuries of the victim is. First one to answer correctly, Sapna, then Aditya and Achal. D is the correct answer, students. This is relevant under section 45. Where handwriting of a teacher is in question, the opinion of his principal may be relevant under section. First one to answer, Gaurav A, Sapna A and Aditya. Top 3 to answer correctly. That is section number 47. A is tried for murder of B by intentionally shooting him dead. The fact that A was in the habit of shooting at people with intent to murder them is first one to answer correctly, Sapna, followed by Amit and Ultra. D is the correct answer, students. That is completely irrelevant. Primary evidence of a document means first one to answer correctly, Sapna, followed by Aditya and Amit. C is the correct answer, students. That is document itself. Photo of a building is what kind of evidence? Primary evidence, secondary evidence, no evidence, none of the above. And top 3 students to answer correctly, Sapna, followed by Kirti and Ultra. B is the correct answer, students. Photo of a building is always a secondary evidence. Which one of the following is not a public document? Arrest warrant, post-mortem report, registered sale deed, charge sheet. And the correct answer is, students, no Amit, that is not the concept that will work here. Primary evidence will remain the primary one. The concept you are talking about is of section 65 basically. Okay, then secondary evidence may be given, but that would be secondary evidence. Okay. Okay, now for question number 21, top 3 to answer correctly, Aditya, Sapna and Amit. Next. Public document can be proved by. How can you prove public document? First one to answer correctly, Sapna, followed by Ultra and Aditya. C is the correct answer, students. That means of certified copies. Presumption as to electronic records and electronic signature under section direct question. They are asking about the section number. And the correct answer is, students, D. That is section number 85B. Aditya is the first one to answer correctly. Okay. Next. Presumption under section 90 can be drawn is respect of first one to answer correctly, Sapna, followed by Aditya and Amit. Original documents. A agrees in writing to sell a horse to B for rupees 1000 or 1500 to show which price was to be given. Choose the most appropriate answer. First one to answer correctly, Sapna, followed by Prasiddhi and Aditya. C is the correct answer, students. A wish to prove a dying declaration by B. The burden to prove that B is dead on first one to answer, Aditya, followed by Sapna and Achal. Top 3 to answer this, students. D is the correct answer. A is charged with traveling on a railway without a ticket. Burden of proof that he had a ticket is on first one to answer correctly, Sapna, followed by Prasiddhi and Shikha. Accused is the correct answer, students. This is basically from your section number 106. Section number 113A is what kind of presumption? May presume, shall presume, conclusive proof, or none of the above. First one to answer correctly, Sapna, Achal and Prasiddhi. This is your may, yes, Shikha and Achal, top 3 to answer, may presume. And 113B is what kind of presumption? First one to answer correctly, Aditya, followed by Shikha and Ultra. Shall is the correct answer. A found in possession of stolen car after the theft. The court may presume. Ultra, first one to answer C. I hope you. Okay, 31C. I hope कि आप 30 ही लिखना चाह रहे थे. Followed by Sapna and Achal. C is the correct answer, students. A is thief. Which section is founded upon the doctrine laid down in Packard versus Sears? This is again a landmark judgment, students. It's okay, you don't need to be sorry for that, Ultra. First one to answer correctly, Sapna, followed by Achal and Amit. B is the correct answer, students. This is basically your doctrine of estoppel under section 115. So this is a landmark judgment, English case law. A document containing a communication from a husband to his wife in the hands of third person. This is basically not their person, students. In the hands of third person. Okay. Third person is now. What are your options? 32 is basically about your third person. So let me. The only student who has answered question number 32 correctly is Shikha Srivastava. That is A, admissible in evidence. Okay, because now it is not in the hands of husband or wife, it is in the hands of third person, so he can give the evidence. Who among the following is not an accomplice? Who among the following is not an accomplice? First one to answer correctly, Amit, followed by Shikha. Students, D is the correct answer. Detective is the correct answer of this question. Okay. Who among the following is an accomplice? First one to answer correctly, Shikha, followed by Ruksar and Amit Pandey. B is the correct answer, students. The statement of solitary witness. Choose the most appropriate answer here now. The statement of a solitary witness. First one to answer correctly, Sapna, followed by Amit and Achal. Students? Okay, just wait. The statement of a solitary witness. And the most appropriate answer here is C, students. So the first one to answer correctly is Ultra. Aditya. C is the correct answer. C. This question is basically from section number 134. In Evidence Act, which has not been mentioned? First one to answer correctly, Ruksar, Sapna and Amit. A is the correct answer, weight of evidence. Any question suggesting the answer is called oral question, specific question, leading question, hearsay question. Ruksar, I request you, please write the question number first, like 37, and whatever your answer is. So sometimes I may be not taking your name because of that only, because I don't know for which question you have answered. Okay? Chaliye. Okay, students, for 37, the first one to answer is Ultra, then Sapna and Shikha. C is the correct answer. That is leading question, section 141. FIR, First Information Report, section 154 of CRPC, can be used for first one to answer correctly, Sapna, followed by Achal and Amit. C is the correct answer. C is the correct answer. That is both for to corroborate as well and to contradict as well. A witness cannot refresh his memory by, choose the most appropriate answer. Okay. I hope you all are able to read the options. First one to answer correctly for question number 39 is Achal, followed by Megha and Kiran. D is the correct answer, students. Power of court to suo moto. This is not sue, this is suo moto. Suo moto. Examine any person at any stage is under section. First one to answer correctly, question number 40, Shikha, followed by Sapna and Ultra, D. D is the correct answer, students. Documents in respect of which privilege has been provided under section 123. What kind of documents they are? First one to answer, Kiran, followed by Shikha and Sapna. Yes, students, and the answer is correct. Unpublished official record. I think this is pretty much basic common sense as well. If the documents are already published and in the public eye, there is no need to, give them the protection of privileged communication. But obviously, if the documents are unpublished, then you need the concept of section number 123. Moving to the next question. All persons are competent to testify unless court consider them they are prevented from understanding the question because of हाँ जी राज, मुझे हिंदी बहुत अच्छे से आती है. आप क्या पूछना चाहते हैं? Okay, 42. First one to answer correctly, Kiran, followed by Sapna and Shikha. D is the correct answer, students. Tender years, old age, mental disease, all these are part of your section number 118. If witness unable to communicate verbally and give evidence by writing or by signs shall be deemed to be. First one to answer correctly, Kiran, followed by Sapna and Ultra. A is the correct answer, students. A is the correct answer. Oral evidence because of section number 119. Under section 122, communication during marriage, available to this concept of privileged communication under section 122 is available to husband only, wife only, both, or none of the above. First one to answer, Kiran, followed by Sapna and Shikha. 44 C is the correct answer. This is available to both. A client says to B, an attorney, I have committed murder and I wish you to defend me. This communication is first one to answer, Kiran, followed by Ultra and Sapna. B is the correct answer, students. This is something which is protected under section 126 of the Indian Evidence Act. So this is one of your, you can say, the example of privileged communication between an advocate and a client. Chapter number 10 deals with I think this is a wrong question, students. So just delete that. I don't think that was a valid question. So just delete that. The examination of a witness by the adverse party shall be called his first one to answer question number 47 correctly is Sapna, followed by Ultra and Amit. C is the correct answer. That is cross examination. The examination of a witness by the party who calls him shall be called his. All the examinations, the meaning of the examinations, okay, the order of examination, 137, 138, both these sections are important for your PT examination. First one to answer correctly, this time Ultra, followed by Sapna and Deepesh. A is the correct answer. A is the correct answer, students. Which of the following statements is not correct in relation to section number 165? First one to answer correctly for question number 49 is Adarsh, followed by Sapna and Kiran. C is the correct answer, students. Question में आपसे पूछा गया था which of the following statement is not correct, which means which is false. So cross examination may take place upon answer in reply of question asked by judge. No, you need permission of judge for that. So as per to section 165, this is one of your incorrect statement. No new trial for improper admission or rejection of evidence. This is under section first one to answer correctly, Kiran, followed by Prasiddhi and Sapna. C is the correct answer, student. This is basically your last section, and from the last chapter, section 167 deals with this concept. Now, anything you are not clear with, any question you want my explanation on, please. Any question you feel you are not clear with, or you want more explanation on the answer, feel free to ask. Amit, I guess we have already enough, and I have covered almost all the questions, Amit. Now, if you still want to spend more time on Indian Evidence Act for your PT purpose, I request you to just go through with the BEAR Act. All the important, all the repeated questions, all the relevant questions we have already done. Since it is only 167 sections, I have repeated most of the questions as well. Okay. So trust me on this. This is more than sufficient as far as this subject is concerned. Okay. You're welcome, Kiran. Students, from tomorrow onwards, I'm starting with the Indian Penal Code on the same timings. Yes, anything else? So this is the schedule of my classes, students. The YouTube sessions, from tomorrow onwards, we are starting with the Indian Penal Code 1860. Okay. There is a special classes going on for RJS as well. This is again completely free of cost. You can attend these classes as well. Okay. And in this week, I'm taking some of the classes for UK APO as well, starting from 10 a.m. In my special classes. So on Unacademy app. Okay. Okay, you're welcome, Ultra. So students, let's crack PCS J with Unacademy. You can always use the code KHATRILIVE for 10% off, and also to get free access of all the special classes available on Unacademy app. Compete with thousands of aspirants and stand out from the crowd. You will get all the subjects here, all the special subjects, all the major subjects, minor subjects, local laws, personal laws, GK, current affairs, everything is available for you. These are some special classes features like interactive live classes, poll for learners. You can raise your hand and you can actually speak with the educator. You will get the notifications, so you will not miss any of the classes. You will get the lecture notes and you can access it anytime, anywhere. India's best educators are available for you. This is the free test series going on, students, so take benefit out of this as well. For RJS, this is the rapid revision series for RJS going on by Faizan Khan sir, Karan Sangwan sir, and Vishwani Bansal ma'am. This is the pricing plan and the plus subscription. The idea is more the months, less the price, and you can always use this code to get 10% off. And once you are a subscriber, students, you can attend all these classes. This is the YouTube and the Telegram channel of Unacademy. And on that note, students, thank you very much. Like, share, and subscribe. Okay. On that note, students, it's time to say peace.